Good evening. This is going to be our continuation of uh, the next item on the syllabus, which is Chapter 19, Sales. I am using a different medium than I did in last week's lectures because I could not get the other one to work. So I've had to find something else to use, and um, I'm going to be skipping some things and going over some things a little bit in detail, but don't forget any of the material that we're going to go over today is going to be used and tested on the final exam. So it is not going to be on your exam next week. Also, as a friendly reminder, the past few lectures I have given you actual exam questions that will be on the exam next week. So if you actually hear the lectures and you listen to the entire recording, you would have already gotten 5 questions. There's going to be short answer questions, and there's going to be 2 essays. It's 10 short answers worth 5 points each for a total of 50 points. And you're going to have 2 essay questions, which I'm also going to give you. And they'll be worth 25 points each. You're going to have 1 hour from the time that I post it to submit it to me via email, and then I'll mark it. Um, the chapter that I'm going to lecture you guys about now, chapter 19, it's probably my least favorite in the entire semester. So if I tell you to quote unquote write something down, it means it's important. And if not, just listen, learn, maybe you'll get something out of it. I'm also going to have my notes up, so I'll be referring to them kind of as we go along. So this is all about the wonderful world of sales. What are sales? Sales are the most common transaction between people. It's between people, individuals, and it's also between commercial entities. And Article 2 of the Uniform Commercial Code governs these sales, except in Louisiana. Again, not something that you actually need to know. And when we talk about leases on items, that has to do with Article 2A. So when we talk about sales, this is a common thing that you already know about. Something that you might not realize is maybe the specifics or the fine-tune interlineations of these items when it comes to law and contracts. But really, Article 2 tries to kind of govern and give guidance. That way, when there's a dispute about a sale of goods, there's a reference point. So people would know, hey, who's at fault? And so that way it gives courts the ability to have consistency when it comes to who's right and who's wrong in a case. When we talk about goods, it is a movable, tangible item. It is stuff. It is the chair. It is the desk. It is not real property. So it is those tangible items which we've talked about in the past. And when we talk about a sale, what does that mean? It's that transfer of goods from one person to the other. It's that ownership interest that is now moved. So if I own a pen and I sell it to you, I sold it. There's a sale that happened of that good. What is the good? It's that pen. When we talk about a lease of an item, you don't actually have ownership. You're exchanging possession of that item. So if you lease a car, what's the difference between leasing a car and owning a car? Well, at the end of your lease, that car is not yours. You have to give it back. The entire time, it's not yours. You just have actually an opportunity to use it. You pay for it every month, right? Which is the same thing as financing when you're actually owning a car, but at the end of a finance term, you own the vehicle. You have that ownership aspect, which is different than a lease. So those are just kind of some of the basic things, fundamentals, if you will. We talk a lot about good faith when it comes to sales. When you have merchants dealing with one another, they have to act in good faith. Bottom line is you're entering into a contract with somebody as in the past, so you're not really supposed to screw them. You're trying to enter something into good faith. You want this contract agreement to go through, and so both sides are supposed to do what they need to do in order to make that anticipated contractual obligation happen. Unconscionability is when something is so egregious in the contract happens that it would be really unfair to actually enforce it. So when is that most often happen? It happens mostly when we have, let's say, a person contracting with a big time company, a little person, an average Joe, who is entering into a contract with a conglomerate company, Apple, Google, Toyota, and they sign a document or they sign a contract or they sign some kind of business agreement that they didn't actually read, they didn't actually discuss, and they've just been kind of swindled, let's say. They entered into an agreement, but the terms were so egregious that no normal person would have agreed to it. So that's the unconscionability factor. When courts look at agreements between merchants, they look at it very differently than when it is an agreement between a merchant and a layperson, because merchants, businessmen, businesswomen, they deal with each other on a regular basis. However, when it's a regular person, one contractual deal or two contractual deals, it's different. They're not doing it on a regular basis, and so the court kind of looks at them with a little more sympathy than they would two merchants dealing with one another. When there is an agreement or there's a contractual obligation between two merchants, courts really give them that freedom of contracts. They give them the ability to contract with one another because they're businessmen and women. They're in that field. They are making the best possible decisions for themselves in order to get whatever they want. So the court is really not going to interfere as long as they both knew what they were getting into and as long as it meets those main contractual obligations that we had discussed before. And when we talk about sales, as long as both sides knew what they were going into, courts are really not going to interfere. So that's that whole mutual assent. Also, when we're dealing with merchants, sometimes you can have an open price concept. If you think about it in the past, one of the things I tried to hammer into you guys is that the more specific in a contract, the better it is. There are some instances where people who enter into a contract can have an open variable, can have an open price. When is that? Let's say a seafood restaurant is constantly buying seafood from the fishermen, and they don't know, it's based on supply and demand, but the restaurant needs 50 pounds or 100 pounds of lobster by the end of the month. But they're going to buy it at the market price. So the market price can fluctuate. It's not a definitive and finite thing. It can change between, day to day, month to month, based on the quantity that's available. So you could have an open price and it would still be an effective contract and an enforceable contract, even with that there. And a variant acceptance, you don't have to worry about that. Manner of acceptance, that's something that we're going to talk about. And when we talk about variant, how do you accept something? Well, there's a different way to accept it. You can talk about, I accept this item based on actually accepting it. You can accept something in part, you can deny it in part. You can, as long as you accept it in a reasonable manner, then you're fine. Whether it's a letter, whether it's an email, whether it's you just accept the items and then you kind of work off of it. It's a pretty open and negotiable thing, and as long as it's reasonable, there's really not a problem with that. A couple of other things I want you guys to know. Again, this is more of a listening, not so much as a writing at this point. Auction. What is an auction? Well, an auction is, you've heard of auction if you've ever used eBay, right? So an auction is when you put something up for sale and people can bid up prices. And so the prices can go up, they can go down. You get the best price and you kind of just steal off of that. eBay is not as big as it used to be. I'm not sure why that is, but I'm sure you all know what an auction is. I'm not going to beat that into a dead horse. Contractual, here, this is something, again, none of this is stuff for you to write down. This is just information. A contract for sale can be modified. Under the UCC now, actually, a contract for sale can be modified with that new consideration, meaning as long as both parties agree to modify a particular term of a contract, it's fine and good. Statute of frauds, this should ring a bell to you. Anything that you're contracting over that's more than $500, it must be in writing in order for it to be enforced. So if you're going to be contracting over anything in excess of 500, it must be in writing in order for it to be enforced. That's the statute of frauds. Actually, that's something that you should write down. Write this down, know it, what a statute of frauds is. Must be in writing in order for it to be enforceable. E-signing, don't worry about that. Parole evidence. Parole evidence is also something I want you guys to know. And it is when both parties enter into a contract with one another, what they want to do is they contract back and forth, right? They discuss things, they change things, they modify things, but this document that they enter into, this final document, that's the final expression of their agreement. That's what they both decide that they want to do. This is it. There's no outside things. I believe I've mentioned this to you guys before at some point or another, but I'm not 100% sure, so I'm going to kind of go over it again. It is the final stage of a contract. Whatever you agree to, you're putting it into that document. So you want to make sure that you don't have any side deals, because those side deals are not enforceable unless they're in writing. So you can potentially get screwed if you're not actually paying attention to what you're doing and doing everything legitimately and putting it in the right way. As I've done the past few lectures, I'm going to now give you another question that will be on your exam. Let me just see here. I took pictures of it because I don't want it to show up on your screen here. Okay, another question that will be on your exam. Give an example of a court enforcing injunctive relief. Give an example of a court enforcing injunctive relief. One more time. Give an example of a court enforcing injunctive relief. Okay, that concludes chapter 19. I'm going to pause this and then do a separate little video thingy under chapter 20. I must say that I have come a long way when it comes to technology. It's like 11:30 at night, but this is the only time that I could guarantee my kids would not be screaming, running around, and that's why I put these videos up for you guys, and then you can kind of listen to them or watch them whenever it's convenient for you. It is a probably maybe a difficult time for a lot of you, so this is just trying to make it as convenient as possible. I recognize that you did see my child run in. I know it's 11:30, but we're all kind of screwed up now with time. All right, signing off, and I'll be back with chapter 20 a little later.